Hi everyone, sorry about the delay, just having a bit of technical issues. My co-host Sahil will hopefully be jumping on when he can. Sahil Verma is a senior lawyer in LegalVision's intellectual property and trademarks team, and I am Silje Anderson-Cooke, and I'm a lawyer in our disputes and litigation team. So before we begin, just going to go through a couple of housekeeping items. So following the end of the webinar, you'll all receive the recording and slides in your email, so no need to take detailed notes. Please feel free to submit your questions in the chat box and we will have some time at the end to go through them. And lastly, please complete the feedback survey after the webinar so that we can improve and be better for you next time around. So also, all attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts, intellectual property, or any of your legal needs. To request your free consultation, please provide us with your email in the survey that appears at the end of this webinar, or you can just drop your email in the chat as well. Great, so today we'll be discussing brands and what to do when your brand is copied. We'll take you through the agenda items you can see there on the slide, which basically cover what the different types of intellectual property are, how to protect them, and how to look out for IP breaches and what to do when that happens. Great, so I'm going to jump in to Sahil's part and try and speak to what he was going to speak to. So what is intellectual property? Well, broadly speaking, intellectual property simply refers to creations of the mind, such as inventions, designs, logos, names, or artistic works. IP that you create provides you with the legal rights over its exclusive use authorization, which prevents others from then exploiting those rights and potentially creating confusion in the marketplace. The main types of IP rights in Australia, especially from a commercial perspective, are patents, trademarks, copyright, and designs. Patents protect inventions and innovations. Trademarks protect branding, such as your name, your logos, your taglines, and symbols. And copyright protects literary and artistic works, and designs protect the visual appearance and aesthetic of certain products. It's really important to note that intellectual property varies by country, which is a really complicated issue, obviously, and some countries have different definitions or means of protections for different types of IP rights. For example, copyright, which we will go through in a little more detail shortly, has to be registered in certain countries, whereas in Australia, for example, it doesn't need to be registered. As this webinar focuses solely on brands and others copying your brand, we'll spend the rest of the webinar focusing on trademarks and copyright. Sahil has been able to join, that's amazing.
Apologies for
that. So I'm now going to talk about intellectual property versus your brand and what the difference is, which is the next slide. Great. So intellectual property refers to creations of the mind, such as inventions, designs, symbols, and names that are used in commerce. But when we talk about brand, we're actually talking about all the different things that make up why and how a consumer recognizes you and what makes you and your business distinguishable and unique in the market. So it's actually more of a fluid concept. Brand encompasses a company's name, it could be your logo, tagline, your overall identity, distinguishing it from your competitors. The thing that distinguishes your brand or makes it recognizable, it could be as simple as the color. For example, Cadbury chocolate, everybody knows that distinct purple color, which was actually able to be protected according to a High Court decision. Or it could be your logo design, your brand name, or a really distinct product, or a combination of these that make you a unique brand, recognizable. Brands, as you can understand, are really important to protect. And in Australia, there's quite a range of ways it could be protected depending on what particular you're trying to protect. Under the Copyright Act, you've got the Australian Consumer Law, you've got common law, but also importantly, trademarks have their own legislation and registration process. In the context of brand protection, trademarks will be your most important asset, and Sahil's going to be taking us through that later in the presentation. But before we do that, let's talk about copyright. So copyright protects original, artistic, literary, musical, or dramatic works. So what does this mean? Some examples which you would be familiar with are books, movies, songs, even software code, and other creative expressions. It does not protect ideas, but the creative expression of those ideas. So once you have the copyright, it grants you with the exclusive rights to reproduce, distribute, display, or perform the work. Copyright can protect your brand assets, which may include slogans, marketing material, artistic designs, website content, a lot of different creative expressions associated with your brand. So you might find that something your business has produced is already protected under copyright. In Australia, copyright automatically subsists in original work as soon as they're created, something that I mentioned before. This means that copyright arises automatically. There's no need to register it like a trademark. As long as the work is original and it exhibits a sufficient degree of creativity, it is granted copyright protection. While registration isn't required, you might consider putting others on notice that you claim copyright over your works by using the little C copyright symbol on the slide, which I'm sure you're familiar with, and put the year of the creation and provide notice to others. And the copyright author's owner's name as well, which will provide notice to other people. Now we're going to talk about trademarks. So I'll throw to Sahil, who's going to go through that in more detail.
Perfect. Thanks, Silje. And apologies, everyone. I had some technical difficulties there. As you can imagine, that was quite a scramble. Let's talk about trademarks. Okay, so whereas copyright, like Silje has just mentioned, protects artistic and literary works, trademarks, on the other hand, are signs that are used by traders to distinguish their goods and services in the marketplace. So trademarks can include, for example, names, logos, sounds, movements, scents, colors, basically anything that a business uses to identify itself in the market, or that's used as a badge of origin for certain goods or services. Now, it's important to note that a trademark is simply another word for a sign. It's not necessarily something that you need to achieve. You are the owner of a trademark if you were the first to adopt that trademark for your chosen goods and services, and you don't necessarily need to register that trademark to obtain rights within your brand. However, registering your trademark provides you with significantly more benefits and protection. Should another business copy your brand? Now, when registering your trademark, you'll need to submit an application to IP Australia, select the trademark and the goods and services that you wish to protect, pay the relevant fees, and then ensure you meet requirements for registration. You may not be able to meet these requirements, for example, if your trademark is generic, scandalous, confusing, or similar to another registered trademark on the Australian Trademark Register. Now, once you've undergone that application process, your trademark rights are then significantly stronger. You will obtain exclusive rights to your branding, depending on what you've applied to register, and then you can enforce your registered rights against a future copycat. Now, importantly, you can then allege trademark infringement against another business if you have a registered trademark, whereas you cannot if you're using your trademark unregistered. Consumers will also have a lot more trust in your brand if your trademarks are registered, given you've effectively proven that you're the rightful owner and provider of certain products and services. Now, here you'll see a bunch of reasons to register your trademark, some of which I've just touched on. Now, to focus on a few points here, registration provides you with an easier enforcement process because it assumes that you're the rightful owner. So you don't have to jump through several hoops just to prove that you came up with a trademark in the first place. Enforcing registered trademark rights against copycats is also a lot easier under the Trademarks Act compared to enforcing unregistered trademarks by other means through the Australian consumer law or passing off, which have a much higher and stricter threshold of proof. Registered trademarks are also a valuable asset should you look to bring on investors or franchise your business. Now, when taking steps to register your trademarks, you'll need to consider, one, whether your trademarks are actually available for registration or whether you yourself are at risk of infringing on another company's rights. Now, this is quite a common scenario, unfortunately, and we do have clients that come to us trying to enforce their rights against copycats, only to find out that they themselves are not the rightful owners of the brand that they are using. And as you can imagine, it can then be quite a difficult feat to do anything about the copycat in the first place. When assessing your trademark registrability, you should also ensure that you check the availability of domain names, business names, and social media handles corresponding to your desired trademark. Consistency across online platforms, brand consistency, helps establish a cohesive brand presence and then prevents confusion amongst consumers. You'll also need to consider whether your trademarks are actually capable of registration, i.e., have you chosen a brand that is capable of being enforced? For example, if your trademark is generic, like the barbershop, have you effectively prevented your ability to stop others from using your brand name purely because it's a brand name that needs to be used in good faith by others to advertise their goods and services, such as, for example, haircutting services? Now, to that end, we recommend choosing a trademark that is unique or distinctive so that it can be instantly registered and then easily enforced. Another consideration are the classes that you include in your application, as that can then have an impact on your future ability to enforce your rights. Classes are categories of goods and services that you select when applying to register a trademark. Now, although there are higher fees for the more classes that you select, we do recommend selecting as many that are applicable to your business so that there are no gaps in your protection moving forward. Similarly, you should ensure that your scope of registered protection is applicable in as many countries as possible, so that if another business were to copy your brand, you're not necessarily limited by jurisdiction. It's common for businesses to assume that a registered trademark in one country extends to other countries too, and unfortunately, this just simply isn't the case. You should ensure to extend your protection to every single country where you intend to offer your goods and services. Lastly, ensure that your application isn't vulnerable to an opposition by a third party. Now, when applications are accepted by IP Australia, they can still be opposed by a third party during that application process if your trademark is too similar to either a registered or unregistered trademark that was used before you in the marketplace. And you can avoid this situation entirely by conducting searches of the marketplace, social media, domains, business name registers, and business directories, for example, before you actually apply for trademark registration. Let's just say you've gone through all of those hoops and your trademarks are now registered for the full scope of protection possible. You should then continue to use your trademarks in the marketplace for all of your goods and services so that your trademark registrations are not vulnerable to removal by a third party on the basis of non-use. I'll now hand it over to Silje to talk about monitoring for infringements.
Thanks, Sahil. We have talked about what is a trademark, copyright, and what falls under this. Now we just want to briefly touch on how do we find out whether infringement is happening right now. So there are ways you can proactively monitor, but usually we find that clients become aware of intellectual property infringement organically. Monitoring for copycats or potential trademark or IP infringement is a really essential practice to protect your brand. So how do you do this? We'd recommend conducting regular searches online, social media platforms, online marketplaces, industry-specific websites to identify any unauthorized use or similar trademarks. Obviously, you're going to be more aware of where these copycats might appear. It will be unique to your brand. Be aware of your direct competitors and how they're promoting their business. Is it similar to yours? Are they copying your posts, anything like that? Be aware and sort of constantly be monitoring what they're doing. You've also got brand monitoring services. You can engage a law firm like LegalVision to assist with monitoring the marketplace, the trademark registrar, both domestically and internationally, to assist with identifying similar brands. If this is something you're interested in, you can actually pop your email into the chat and book in a free consultation. This is definitely a service that would be worthwhile. Also, consumer feedback. So your customers might notify you of a copycat or defamatory online review. You might get some feedback from your actual customers, and that might be how you discover intellectual property infringement. Now I want to pass back to Sahil, who's going to talk about taking action on IP infringement.
Perfect, thanks Celia. So yeah, now that we've talked about registering and protecting your intellectual property rights and monitoring for instances of infringement in the marketplace, we'll now talk about what you should do if or when you come across someone who has actually copied your brand. So generally speaking, the first thing that you should not do is get in contact with that business. You'll need to first monitor the activity of the other business and collate as much evidence as possible. And this might include, for example, taking screenshots of the infringing activity or documenting any instances of confusion. Once that's done, you'll need to assess your own legal position by speaking to an IP lawyer, preferably. Now, the benefit of this is to understand if there are any gaps in your own protection and whether the other business might have any counterclaims against you. Your lawyer will also review the screenshots that you've collated to assess if there actually is a claim there. Now, if it's been established that there is a claim, that's when you can take action. And there are several formal and informal ways of taking action, which we'll discuss in a second. However, before we do, just a quick note that you should consider taking action as soon as possible after identifying the infringement. And the reason for this is because the longer you wait and the longer the other business uses the infringing trademark, the stronger the other side's defense will become as they will then have a claim that they were using their trademark honestly and concurrently alongside you for an extended period of time. And therefore they deserve registration rights themselves. This is called the honest concurrent use defense, which is a little bit annoying when you're trying to enforce your rights. So naturally we want to avoid that being brought up at all, and you should nip it in the bud as soon as practically possible. Silje, do you want to now chat about the informal ways of taking action?
Thanks. Thanks, Sahil. I think that's a really good point about and one of the many reasons why it's important to act swiftly when you find intellectual property infringement. And whether that's an informal process to begin with or formal, acting quickly and getting advice about whether there is intellectual property infringement as soon as possible will always put you in the best position. So in relation to informal processes, there are many reasons why we may decide to take an informal route to begin with, and it's going to depend on the nature of the infringement you've discovered and how much it's actually worth to you and the impact it's having on your brand financially. Obviously, if we're talking about a really high value impact on your business, you might decide to start with a formal route. Hypothetically, if it's a lower value, we might suggest contacting the infringing party and clearly explaining your ownership rights and the potential infringement, and request that they cease using any infringing material, marks, and modify their branding or publications to avoid confusion in the marketplace. It's also really good to collate not just screenshots of any infringement, but any detail on the impact that it could be having on your business. For example, if you've got your customers reaching out to you and emailing you and saying, I got confused and clicked on their website and went through the process when actually it was you that I was looking for, I just got confused by the branding. All those emails, and you want to have evidence and collate that, it makes it easier to explain the harm that the infringement is causing. You can also explore as an informal process takedown options through the social media platforms or online platforms that it might be occurring. Most social media platforms have a process where you can fill in a form if infringement is occurring, and they will deal with it through their internal process. There's also, if it's a domain dispute, there is a way that the domain administration provides an alternative to litigation and operates a process for parties to raise and resolve any domain name disputes through their process. So now I'm going to throw back to Sahil, who's going to talk in more detail about trademark specifically oppositions.
Thanks, Celia. So alongside these informal processes that Celia has gone through, you can also consider opposing another trademark application if another party has applied for one. And this course of action is relevant regardless of whether you've registered your own trademark or not. If you notice that another party has applied to register a trademark that is similar to a trademark that you have used before, either registered or unregistered, and the goods or services that you have elected are similar to theirs, then commencing an opposition is in your best interest. Now, to be clear, if you have registered your own trademark and another party has applied to register a similar one for similar goods or services, it's very likely that IP Australia will initially object to that other application being accepted. However, mistakes do happen, and you should be ready to file an opposition should it become necessary. And that's when those monitoring activities come into play. If you're consistently and routinely looking at the trademark register, you can identify these potential mistakes and take action. Being opposition savvy is key in ensuring that you retain brand monopolization. If you aren't, and another similar trademark does register for similar goods or services to yours, you then share a portion of the market with that other trader. And this would obviously affect the exclusivity of your rights, then lead to brand dilution and then consumer confusion later on. Now, Silje, let's chat more about formal ways of taking action, such as court litigation.
Thanks, Sahil. So as a very last resort, you might consider litigation. If you become aware of another business that you consider is copying your brand, you might need to consider litigation in the Federal Court of Australia. So this is the forum to enforce your trademark and your copyrights. You might also allege that this copycat business is engaging in misleading and deceptive conduct under the Australian consumer law or passing off, which means that the copycat business is trying to essentially trade off the goodwill that you've established, the brand that you have built, and or mislead consumers into believing that you are associated in some way. Now, before you commence proceedings, you should always engage a lawyer, and the first step is likely to be to prepare a more formal cease and desist letter, which demands that the infringing business party immediately ceases the infringing activities and may request compensation or other remedies. So when I was talking about making sure you collate evidence of any damages to your business, this is why it would be most relevant. If you decide to go down a formal route, you need to start collating this type of evidence. As an alternative to court action, you might be able to negotiate and reach a compromise with that business. It's highly unlikely that you'd get to, if you were to commence proceedings, to the hearing stage. I think only 1% of actions that are commenced in a court actually proceed to the final judgment. So it's more likely that you would negotiate an outcome throughout the litigation process and either agree on some ways that you will go forward or a form of a coexistence agreement, for example. If you do need to commence proceedings, the things that the court can provide as remedies to infringement are injunctive relief, which means stopping the infringement from continuing. So essentially getting an order from a judge to say, you know, they're not allowed to do this anymore. Damages, financial compensation for the losses suffered as a result of the infringement, and an account of profit. So any profits that that business has derived as a result of the infringement could become part of the compensation that you receive. So litigation can be a really costly process, or it is a really costly process. However, it's really important to consider this and weigh this up against the risk of damage to your business reputation and enforcing your intellectual property rights. You should get legal advice to consider if litigation is the best option for your business, and note that you may still be able to pursue legal action to enforce your intellectual property rights, even if you haven't registered your trademark, as Sahil has mentioned previously. Now I'm going to throw back to Sahil, who's going to touch on some really important jurisdictional matters to consider as well.
Thanks, Silje. So what I'm about to go into might actually relate to a few questions that I can see have just been submitted relating to international rights. So we've spoken a lot about what to do if your brand's copied in Australia, but it's important to recognize that many businesses, including online businesses, conduct trade across borders. And so it's very likely that an infringement may occur in a different country. Now, as I mentioned earlier, you should preempt third-party infringement by ensuring you've applied to register your trademarks in all of the countries that you operate in, given that your rights are only enforceable in the countries where you file and use your trademarks. Now, in certain countries, the rightful owner of a trademark is actually the first business to file the application. not necessarily the first business to use the trademark in the marketplace or adopt it. And so unregistered rights aren't uniformly recognized across the world. And this is particularly true for countries like China, where they have a first to file system. Essentially, the first person to file the trademark gets the trademark. And that simply isn't the case in countries like Australia and the UK. Now, if an infringement occurs in another country, you should speak with an IP lawyer to understand which country is best suited to bring a claim against that other party. For example, it might be easier to prove infringement in a particular country like Australia or the US compared to a country like China. You may also need to consider the time that it takes to resolve claims in countries like China, where so many applications are filed on a daily basis and many infringements occur. All right, so I now hand it over to Silje to summarize the key takeaways of this webinar.
Thanks, Sahil. So our key takeaways. Number one, be proactive about protecting your brand. And this starts with identifying and, where possible, registering your intellectual property and your trademarks. Number two, monitoring for brand infringement. As I said, LegalVision offers this service of monitoring any sort of trademark registers in the marketplace. This is a really good idea to stay on top of your brand and protect it. And then number three, if you are aware of intellectual property infringement, take action quickly. I cannot emphasize this enough. It's always going to put you in the best position if you get advice as soon as you become aware of any trademark intellectual property infringement. Building up a strong brand is really hard work, and you don't want all that hard work to be for nothing. So if you aren't already, you need to think about your brand as an asset to your business that needs proactive protection. And for many businesses, it can be one of your strongest assets, especially if you take the steps to safeguard and protect your brand. That concludes the main part of our webinar. You might find our Trademark Essentials Guide useful, and you can download this by accessing the handout panel or scanning the QR code, which is on your screen right now. And then we also have an upcoming event that may be of interest to you on tips for franchisor legal compliance. You can register on our website at the link on the screen. And we're going to answer your questions shortly, and you've got some time now to pop them in the chat. While you submit them, we'll just take a minute to talk through our membership. So our membership is a cost-effective alternative to the expensive hourly rates that you experience with most other law firms. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services, including unlimited document review, including drafting, amending, and reviewing business contracts and commercial leases. It includes unlimited advice consultations with our team of over 100 specialist lawyers, including business structuring, employment disputes, and more, and unlimited domestic trademark applications, which is very relevant to who we are speaking to now. As a LegalVision member, you don't have to worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We basically take care of all of the business as usual legal work, so you can focus on running your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how membership can help you, you can actually request a free consultation when the survey appears at the end of this webinar, or just pop your email in the chat. Now we're going to answer some of your questions. I'll throw to Sahil, who was going to answer the first one, I think.
Perfect. Yeah, look, there's a few that have come in relating to trademark applications, so I might actually address two at the same time.
Great.
So one is, I'd like to register two of my logos as trademarks. How do I go about it? The products are currently being made in China. So in order to register a trademark, I did mention this a little bit earlier in the webinar. Essentially, what you need to do is submit an application to the relevant trademark office. Now, in Australia, that's IP Australia. Internationally, it really does depend on the country that you're targeting your application to. For example, in the US, it's the US Patent and Trademarks Office. In the UK, it's the UK IPO. It's pretty much the same process in every country. It's essentially identify which trademark that you want to register, identify the goods and services that you intend to provide under that trademark. So that might be, for example, class 3 for cosmetics, class 25 for clothing, and class 36 for financial services. That's obviously a very strange business, but it happens. Once you identify your trademark and your goods and services, identify who you wish to own the trademark. That might be, for example, your company or a holding company that specifically holds intellectual property, or it might just be yourself as an individual. Once you've identified those 3 key pieces of information, you then submit your application to the relevant trademark office. They review your application and assess if that trademark should be registered. And if it does become registered, you then get a certificate. You can then go on and enforce your rights against copycats. The relevant question, sorry, the second question that's quite similar to that is, can variations of the same logo be submitted under a single application? For example, a logo in 2 different colors, a logo by itself, or another with text. It's a little bit of a tricky question because it does depend on the country that you're filing in, but specifically for Australia, just assume that each trademark requires its own application. So for example, if I have a logo, just say the McDonald's Golden Arches, and then I have a word trademark, McDonald's, they are 2 separate trademarks, and therefore they require their own separate applications. It may very well be the case that one of the trademarks is accepted and the other one just isn't. So they should be in their own separate applications. The only exception to that is when the trademarks that you're applying for are virtually identical. So they might literally be the exact same logo, but in 2 different colors. If that's the case, you can combine the 2 into the same application. That's called a series application. Obviously, seek some advice there. You don't want to file a series application and realize that the 2 trademarks are slightly different and you've lost your government fees. Essentially just get some advice there before filing. There's a question here for you, Silje. What can I do to prevent employees taking IP when they leave the business? I'm assuming from a branding perspective.
That's a great question. There are many different ways that you could protect your IP from employees. The best way to protect your IP is actually to have really good employment agreements in place. So your best bet is your confidential information clause and your restraint clauses, or that sort of suite of clauses that are usually included in an employment agreement. The tricky part is they really need to be drafted well to make sure that they're enforceable. So if this is something that is a concern to you, I would be popping my email in the chat and booking in a free consultation. You can meet up with one of our employment lawyers in our employment team to talk about that, because having your employment agreements really watertight will be the best bet for preventing employees taking your intellectual property. Obviously, the second advice for that would be just reviewing your general processes. So if you have intellectual property just on an open drive where any employee can access it, even if that's not actually part of their day-to-day job, you might want to think about restricting what people have access to so that they can't find, if they don't need it as part of their job, they shouldn't need to access it. Restricting who's able to access it will also assist you. That would be my answer to that question.
Cool, thanks, Silje. There's a lot of questions coming through, so I might just move along to a few more and maybe address
rapid
2 at the same time again. Sorry, what was that, Silje?
We'll do rapid fire.
Yeah, we'll do some rapid fire question answer. There's 2 here which I think I can probably answer with the same answer. So what happens if a website name infringes on a trademark from another country? Can that foreign company claim anything if your website is owned by an Australian company, so it's used in Australia? Look, the quick answer to that is it depends on if the owner of that website name in the other country has any rights in Australia too. So as we mentioned, there are jurisdictional considerations when it comes to trademarks. So if that other country, let's say it's the US, they have a significant reputation in the US and they're trading there, they've registered their trademarks there, or they haven't registered their trademarks there, it doesn't really matter. They have rights in that country. You independently have your own rights in Australia. That should be fine. There is coexistence internationally. A consumer is less likely to be confused when those trademarks are being used by completely different businesses in completely different countries. Now, there are obvious exceptions to that, is if the reputation in that US company, for example, is quite significant. So let's say they're a Starbucks, they just haven't really come to Australia yet. That's when there's minor exceptions there. You know, the other side could argue they have a spillover reputation that extends to other countries, even if they haven't registered a trademark there, like in Australia. The second similar question to that is, I'm currently looking at working with a Japanese distributor for my Australian fashion label. How does it work in terms of trademarking when going overseas or working with overseas distributors? Very similar. Just ensure that you're applying to register your trademark in whichever country is relevant there. So in that instance, Japan and Australia would be the two key considerations, and then obviously any other country where you might manufacture your goods or sell those goods as well.
I'd also say for that one, I'll just jump in with when you're working with overseas distributors, it's really important to have a good agreement in place that basically protects your intellectual property between the two of you. And you could have jurisdictional clauses that make the contract an Australian contract. So if there's any issues, you can enforce your rights through Australian law. And that's something, you know, obviously we can help with reviewing documents as part of our membership. Yeah,
perfect. Silje, there's one here for you, which is a really good question. What do you do when another account takes your social media content and posts it as their own? So what if a person replicates your whole business, including creating a website, similar URL, and then consumers incorrectly believe that that's your business instead?
Yeah, that's a great question. I have seen that before, and it's really frustrating. And unfortunately, in the digital age, it can be easier to just copy businesses like that. So there's several different actions you could take. The main one would be under the Australian consumer law, misleading and deceptive conduct. Obviously, if they're taking your content, you'll have rights under copyright, potentially trademark if they're using your trademark. But misleading and deceptive conduct would likely be your biggest claim, and it'd be to do with misleading consumers into believing that this website is actually your business when it's not. Potential fraud argument there as well in terms of a criminal action, if they're basically, you know, completely being fraudulent. So yeah, you would essentially, if you saw that, you'd be reporting them to the platforms as soon as possible. As we've already said, take screenshots, evidence, and then contacting your lawyer as soon as possible to talk about what type of action you can take.
Perfect. There are 4 trademark related questions here, Silje, so I might just do a rapid fire for each of them. And I appreciate that we're just about to run out of time, but I did jump on a little late, so I'm happy to extend the time just a little to answer these questions for you. One here is, I've recently started a Head Start application for a word trademark, and I also have a logo to register. Is it best to wait on the feedback for the word before submitting an application for the logo? Obviously, the answer, it depends what's in your logo. If your logo is essentially just the words, but let's say you've included a device or a symbol next to the words, kind of depends how confident you're feeling with the word trademark. If you've done the relevant searches of the trademark register and you don't believe that your word trademark is too generic or it's scandalous, there are any other issues with it, you could just go ahead and file the logo application. I note that you've said a Head Start application there. So for those who don't know what a Head Start application is, it's a very quick turnaround assessment from IP Australia, where they review and examine your trademark in 5 business days. So if you've already filed your Head Start application, there's essentially less than 5 business days to go to wait for that examination. I would just recommend waiting. Let's say, for example, you receive 25 different objections for that word trademark. It obviously would then inform you as to whether it's worth filing for a logo at all, or whether it's it's worth rebranding the entire business. And that's obviously where you can get in touch with a trademark lawyer. We can do those searches and provide you with advice before you spend any more money on government fees. Do you need to register a trademark application for an icon, i.e. a simplified version of your main logo? That completely depends on how you use your trademarks. So best practice is to register as many trademarks as you use in the marketplace. So let's just say, for example, you use your business name as a word trademark. You have a main logo that you put on your products or your website, your logo trademark, and then you use another icon. Maybe you have a downloadable software application, and that little icon is what appears on people's iPhones. Register that one as a trademark too. And if you use a different logo, register that too. The reason for that is because if someone copies your brand, but only copies one of the 4 trademarks that you've registered, you'll be so thankful that you registered that 4th one, because it's then easier to enforce your rights and allege similarity. So yeah, the quick answer to that is register as much as you possibly can. You basically it's basically an insurance for something that might happen in 3 to 5 years' time, and you'd be so thankful that you registered everything that you could. Sorry, just reading through the questions here. If your trademark is just a black and white version of your logo, would it protect you if a competitor copied your logo but applied a different color? Yes. So in Australia, in a lot of Commonwealth countries, the trademark that you file is protected in every single color. So if you file in orange and blue, you're still protected in red and green. So if someone copies your logo but applies a different color, you can definitely go after them. So within the realm of your protection. But also something to keep in mind is when you're enforcing your trademark rights, you're enforcing them against anything that's substantially identical to what you registered or deceptively similar. So even if someone slightly varied a logo that you've registered, if it's still deceptively similar to you, then you can enforce your rights. And color changes are still deceptively similar, in my opinion. I have one more question before I think we should wrap up. And sorry to just hog the microphone there, Celia, but it's very expensive to do a blanket trademark submission for multiple countries. How difficult is it to grow the geography of the protection as the business brand grows and expands? I completely agree that it's quite expensive to do an international application. So for those who are not familiar with international trademark applications, basically there are 2 avenues for this. You can file in your base country and then use something called the Madrid Protocol. And I definitely recommend reading up on the Madrid Protocol or getting in touch, and we can have a further discussion on this. It's basically just an international trademark filing system. Alternatively, you can just go directly to whichever country you want to go to. So Australia and Japan, and that's it, file 2 direct applications. Now it can be expensive both routes if you've got 10 or 15 countries that you want to include. So how difficult is it to grow the geography of the protection as the business grows and expands? It's a bit of a difficult question to answer, but I will personally say it's difficult to grow the business, especially in other countries if you haven't registered your rights there. So it's a bit of a catch-22. Should you go and trade and see if a business is actually worth entering before you register your trademarks? Or should you register your trademarks and then go to the business, sorry, go to that other country? It's a difficult decision. You might want to test the waters, but testing the waters might end up in a legal dispute if you realize there's a registered trademark in that country. The best thing that you can possibly do, in all honesty, is apply to register your trademark in that country, see what that government says. They might not raise any issues, and then you're free to trade. And searches of the trademark register, although helpful, are not necessarily, unfortunately, a guarantee that you can go and trade in that country. We can do searches for you, and a different country might have a different idea of what is similar. So the best bet is just to, unfortunately, just kind of bear the upfront investment and just file in that country.
I totally agree with that. I had a client who had established their business in Australia and had every intention of expanding into the US. And by the time they were getting to that point, realized that they had a competing, like a business with the same name in the US pop up, which can be really frustrating if you haven't. Basically, I think what you're saying, Sahil, is if you know you're planning on international expansion, when you know that, you should start thinking about trademark registration ahead of time.
Yeah.
And that's going to put you in the best position to expand overseas.
Agree. And just to add something there, some countries are very slow. So I mentioned 5 business days in Australia, probably the fastest country there is, to be honest. Canada can take up to 2 years. So it really, it's just unfortunately, if you see yourself going to Canada in a few years' time, I would probably get started an application now.
Great advice.
All right, I think we'll wrap it up there. Try to answer as many
Yeah.
questions as possible, but obviously if you have more questions, feel free to to get in touch, to book your complimentary consultation, and obviously become a member with LegalVision, and we can just iron out these issues for you as well.
Yeah, and we'd really appreciate if you could complete the 30-second survey. Please include your contact details to receive your complimentary legal consultation to discuss how we can help you with your intellectual property needs, especially if we didn't get to your question today. Sorry about that. Thank you so much for joining us.
Thanks, guys. Have a good day.